a few seconds to start a live stream, then I will open the meeting. All right, the ICC is now in session.
Good morning, everyone. The International Criminal Court is sitting today in the case the prosecutor versus Mr. Graus. It's a pre-trial chamber hearing. We are dealing today with several challenges to the admissibility and jurisdiction of the court. My name is Gleb Bogush, and I will be presiding over this hearing. And I kindly introduce my fellow colleagues also to introduce themselves. So please, Judge Sémien.
Thank you. Good morning, everybody. Mr. Eric-Aimé Sémien. I'm judging in this session.
Thank you.
So good morning, everyone. So my name is Kazushige Doi. So I'm teaching criminal law basically in Japan. So I'm really happy to join your session.
Thank you very much. Well, we now turn to appearances. I would only kindly ask briefly introduce the parties to introduce their teams and let us know the time allocation. So we start with the Office of the Prosecutor, please.
Your Honours, my name is Madison Winan. I appear alongside my learned co-counsel, Jeremy Brown, on behalf of the Office of the Prosecutor. I'll plead for 12 minutes and we'll deal with the jurisdictional challenge. My co-counsel will plead for 13 minutes and we'll deal with the admissibility challenge and also the mode of liability.
Thank you. Defense, please, could you also introduce yourself?
Good morning, Mr. President, Your Honours. My name is Natalia Mai, and alongside me is my co-counsel, Mr. Lim. Together, we act for the accused, Mr. Gravis. I will address this court for 15 minutes, while my co-counsel, Mr. Lim, will address this court for 10 minutes. We respectfully reserve 5 minutes for a rebuttal.
Thank you. Yes, the parties have right to rebuttal and rebuttal up to 5 minutes, according to the rules. So following our agenda, we start with the submission of the prosecution. So you have the floor.
Thank you, Your Honour. May it please the court. Today, I will make submissions on the challenge to jurisdiction made by the defence under Article 19, Paragraph 2A of the Rome Statute. Here we submit there are reasonable grounds to believe that the case against Mr. Gravis concerning the crime of genocide under Article 6A and also Article 6C falls within the jurisdiction of this court. We say that the relevant genocidal acts were targeted against the Castilian ethnical group with the intent to destroy the group in part. On this basis, we submit that the case should proceed to confirmation of the charges. As our first submission, we say that territorial, personal, and temporal jurisdiction are present because the case has been referred to the ICC prosecutor by the UN Security Council. Therefore, we will focus our submissions today on the court's subject matter jurisdiction, where the pre-trial chamber must find only reasonable grounds to believe that the elements of genocide are satisfied. These elements are, firstly, that the victims were from a protected group. Secondly, that an act listed in Articles 6A to E was committed. Thirdly, that there was an intent to destroy the target group in whole or in part. And finally, the contextual element, which requires a manifest pattern of similar conduct directed against the group. Turning to the identification of the group, We say that the Castirians were targeted in their capacity as an ethnical group. And we say that the group is ethnical rather than political, for example, because of the strong focus of Mr. Graves's campaign on Castirian civilians. We see women and children as key victims of the famine at paragraph 15 of the facts, for example. And we suggest that women and children would not typically be considered key targets of a political campaign. We also see the use of racial pejoratives and derogatory language at paragraph 10 of the facts, which the ICTR recognised in Kazushige can be a feature of genocide cases and indeed an indicia of genocidal intent. We would also submit that it is incongruous with a political identification of the group. We also say that the testimony of Mr. X is an important factor identifying the Castirian ethnical group as the target of the acts, rather than Castirians more broadly as inhabitants of the Castirian province. Mr. X is a resident of Castiria, but we can see at paragraph 13 of the facts that he is indeed released after a National Directorate of Security officer learns that he is Hanu. And this shifts the focus of the attacks from being on the region more broadly to the ethnicity, the Castirian ethnicity. Mr. X's testimony is anonymous hearsay. However, we submit that the court can and should use the testimony. This is because, firstly, it has significant probative value, and Mr. X is a key witness for the prosecution. His testimony has the ability to substantiate facts and issue and bear on the findings in relation to the elements of genocide. Secondly, we submit it as likely that Mr. X will be able to testify at the trial stage and that his evidence can therefore be tested. And we recognise that this is a key hesitancy in using hearsay evidence, often the lack of ability to test the evidence. But in the current case, we submit that this...
Council, may I stop you here? As I understood you're focusing specifically on this particular episode, the testimony of one witness, and so it's the only fact that clearly demonstrate that the target, the accused, and these forces under his command targeting specifically ethnic Castirian, just on the basis of ethnicity. Are there any other indicators that show that ethnic Castirians, not the SNF members, have been targeted?
Yes, Your Honour. So to clarify our position, we say that Mr. X is an important witness, but he is far from being the only piece of evidence that the Castirians were targeted on the basis of their ethnicity. Turning to Your Honour's question about the distinction between targeting Castirians as against targeting the CNF, we would submit that the ICTY in the Gillesich case has held that genocidal intent can be inferred from the circumstances of the situation, which we submit would include both statements and conduct. Here we submit that the only genuine basis to perceive the CNF as being the intended target of the attacks is statements made by Mr. Graves. Even then, we say that these statements consistently say the CNF and their supporters. Mr. Graves says this both in his national address at paragraph 10 of the facts, and also this is the wording used in the counterterrorism orders at paragraph 11 of the facts. So his public rhetoric has consistently defined the group as being broader than just the CNF. But nonetheless, if we say the court is inclined to view the CNF as the target, we say that, again, it is only those statements, because all other circumstantial evidence points towards Castirians being the target. Indeed, all other evidence is inconsistent with CNF being the true target. Here we would point to the fact that only 1% of the Castirian men killed were CNF soldiers. And here I'm referring to paragraph 12 of the facts, specifically in the town of Luz and Luzari. We also say that the Hanatun forces conducted arrests fairly indiscriminately. They made no genuine attempts to ascertain who was an active CNF member and who was an ordinary civilian, so to speak. At paragraph 10, we know that they pressure Mr. X to confess he is a CNF member, rather than making bona fide attempts to ascertain this. And we submit that if it was important to Mr. Gravis and his forces to ascertain CNF members, they would not conduct themselves in this manner. And finally, we say that Honiton forces have consistently gone further than was necessary to identify CNF members. So if the court is inclined to view, for example, the blockade as being an important measure to track down CNF members, we would ask the court, was it necessary that the blockade would last for nearly 2 months? Was it necessary that all food and resources into the region were blocked such that famine resulted? Your Honour, these reasons collectively are why we do not accept the CNF as being the identification of the group. Therefore, I would like to turn to the material elements of the crime, having discussed at length the group. Firstly, we are looking at killing under Article 6A, where we refer to the 200 Castilian men killed in Luz and Luzari, which I have referred to previously at paragraph 12 of the facts. And additionally, we refer to the 86 victims, Castilian men, shot in the head at paragraph 14 of the facts. And we suggest that shooting in the head is a particularly egregious form of killing, which we say goes towards Mr. Gravis's genocidal intent.
Can you clarify why you believe that this particular method of killing is indicating genocidal?
Yes, Your Honour. So in support of that argument, this is more of a factual argument about the circumstances of killing. It's not so much that we are making an analogy to other jurisprudence, but we say that there is jurisprudence to support the notion that the general manner in which forces conduct themselves can be indicative of genocidal intent. We noticed that the Castilian men were shot when they were resisting arrest. And if the purpose was purely to prevent these men from resisting arrest, the forces could have, for example, shot these men in the leg so as to prevent them from escaping. But instead, they've chosen the very direct and quite egregious form of shooting these men in the head. So we say this is part of the factual and circumstantial matrix in which Honiton forces are conducting themselves in a particularly violent and particularly derogatory way. Turning to the conditions of life inflicted under Article 6C, which is the second charge of the indictment, we are talking here about the famine, as mentioned previously, as causing not necessarily a direct death, as direct as killing, but which the methods imposed, which did result in the death of Castilians, as we see at paragraph 15 of the facts. I would like to address now the specific intent required for genocide under Article 6.
Excuse me.
Yes, Your Honour.
Can you hear me?
Yes.
Okay. Mr. Gravius, he said that the country was facing terrorism act. You don't think that challenging these threats, all the operation ordered by him could be a simple policing operation, as stated earlier by my colleague, the presiding judge. Can you show us what specifically show that genocide acts were committed and willingly by Mr. Gravius?
Yes, Your Honour. So I'll address your question in two parts. So firstly, your question relating to the policing of the national security threat as it was labelled by Mr. Gravis. We submit that this may have been a motivation of Mr. Gravis, but that the court is not precluded from finding genocidal intent. On this point, we rely specifically on the Gillespie case at paragraph 49, where the court, the tribunal rather, found the necessity of distinguishing between motive and intent. It is not fatal to our submissions that Mr. Gravis might have had political motivations for carrying out this campaign, but the manner in which he chose to do this, we say on reasonable grounds, reaches the threshold of genocide. Turning to Your Honour's second question about whether Mr. Gravis willingly committed genocidal acts. Here we would say, firstly, that we are submitting Mr. Gravis has a broad genocidal intent as required by Article 6, and that he has a genocidal plan. But our submission is not that Mr. Gravis personally committed genocidal acts. Rather, we are making submissions under Article 28 that the acts of killing and the conditions of life inflicted can be attributed to Mr. Gravis as leader, and they are also consistent with his overarching genocidal plan. I will quickly just address the contextual element, as this is the final element required at this stage of the proceedings, which is imported through the elements of crimes. We note that the only jurisprudence on this point is the arrest warrant decisions.
Counsel, could you briefly clarify, is it binding on the court, this element?
Your Honour, there are differing opinions on that point. And again, because we only have the one decision, the majority held that it was binding on the court. However, we note that the dissenting opinion of Judge Ushaska noted that she did not believe that the court had to interpret this element. But being conservative, we have chosen to make submissions on this point. And we also note that Judge Ushaska posited her own view of the test as well for manifest pattern of similar conduct. Under the majority's test, we say that there is a concrete threat in the 286 killed and many others arrested. We say that this extends beyond a latent threat. It is no longer simply hypothetical. Applying Judge Ushaska's test, which is assessing the plain language, whether it's systematic and there's a clear pattern of conduct, we say that the manner in which the NDS and SBG conducted themselves was highly systematic and coordinated. But in lieu of the time, I will now, having made submissions that there are at least reasonable grounds to conclude the jurisdiction of the court is enlivened, I will defer to my co-counsel now to address mode of liability and the admissibility challenge.
Thank you.
Mr. President, honourable judges, may it please the court. Your honours, I seek to move these proceedings to the question of the doctrine of command responsibility, specifically found under Article 28A of the Rome Statute, as Mr. Gravis is both the Commander-in-Chief as well as President. Your honours, the jurisprudence of the doctrine of command responsibility has held it to be ultimately a question of negligence. And that is to say whether...
Can you before you turn to your submission, actually explain the choice of command responsibility in this case? So your co-counsel just explained to us that the prosecutor alleges that accused has genocidal intent to destroy the group. And then you say that, well, he's just responsible as superior. It could be seen as the easy work for the prosecution, because it's a reduced mental element in the command responsibility. Can you explain your strategy, just why you choose this command responsibility, the Article 28, not Article 25?
Yes, Your Honour. Of course, Article 25, 3E, for instance, would be a suitable vessel by which to attribute personal criminal liability to Mr. Gravis in the present case. However, we submit that the sui generis notion that carries with Article 28, the disregard for a mental element, does make it far easier to prosecute for the entirety of the crimes, as opposed to Mr. Gravis's specific crimes, or the crimes that he commits of his own accord. And that is to say that in the present case, we seek not only to attribute responsibility for the crimes that Mr. Gravis has committed, but also the consequences of the broader crimes of genocide. And that is to say that we seek to attribute essentially responsibility for all of the deaths and all of the destruction that has been caused. That, in conjunction with the presence of Article 28 on the agenda, has directed us, towards believing that that is the suitable mode of liability in the present case, particularly given the trial chamber's decision in the prosecution of Mr. Jean-Pierre Bembagombo, where they held that these are two different forms of liability that can run concurrent to one another. Your Honours, we submit that in the present case, ultimately three aspects need to be made out in order to attribute such responsibility to Mr. Gravis. These are, of course, the superior-subordinate relationship, the requisite degree of knowledge on behalf of Mr. Gravis, and finally, we need to show that there is a failure on his behalf to execute his duties to either prevent the commission of the crimes or upon their perpetuation to repress and subsequently to punish the perpetrators. Your Honours, in the present case, we submit that the critical aspect for the prosecution to make out will concern knowledge ultimately. And we submit this on the basis that concerning the superior-subordinate relationship, Mr. Gravis is, of course, the de jure leader of the state of Hanatun. He's both the president and the commander-in-chief. And there is nothing to suggest that this form of power has been in any way undermined and that there is an alternate de facto leader. Your Honours, we make this submission on the basis that if I can take the court to paragraph 11 of the agreed facts, we see that Mr. Gravis passes down the counterterrorism campaign in May of 2019. As soon as June of 2019, these orders are in effect. We see troops on the ground in the relevant region with the relevant actors carrying out their roles. We submit that on this basis, there's nothing to suggest any notion of dissent or that there is Mr. Gravis's power has been usurped. Accordingly, Your Honours, we submit that...
Excuse me. Sorry to interrupt. Mr. Gravis has commander. Was he appointed commander or did he declare himself as a military commander? What's the legal basis of his position?
Yes, Your Honour, he did declare himself as commander. We can see that at paragraph 6 after the military coup, and then paragraph 7, where he once again declares himself president and appoints a cabinet. We submit that given the status of Mr. Gravis and his leadership at this juncture, he's been in that role for nearly 4 years. There's very little to suggest that he isn't operating as commander-in-chief and president. But even if that were not the case, it remains the fact that he would be the de facto leader and that there is nothing to suggest that his effective power, that is the power to prevent or repress, has in any way been quashed. Your Honours, concerning the element of knowledge, we submit that there are, of course, 2 standards that can be applied, either actual or constructive knowledge. Now, prima facie, we submit that actual knowledge isn't present on the facts. We acknowledge that there is no paragraph that states that Ms. Jolie, Mr. Bryan, and Mr. Gravis have sat down and discussed the specific occurrences within the Castilian region. However, I would seek to take the court to 2 decisions made in the prosecution of Mr. Bemba, the first from the pre-trial chamber and the second from the trial chamber, in which it was held respectively that actual knowledge can be found through either direct or circumstantial evidence, and that subsequently the leader need not know of the specific actors or indeed the specific nature of the crimes committed. Rather, they must have a general understanding about the nature of what is going on in the region. Your Honours, we submit that in the present case, actual knowledge can be found on the basis of both circumstantial and direct evidence. And I would submit that the evidence that we will rely upon are factors like the commander himself making the order, the temporal nexus between the making of the order and its ultimate commission, the availability of communication between the commander and his subordinates, and finally, the existence of the reporting system found at 11E of the agreed facts. Your Honours, we submit that these circumstantial factors are corroborated by, firstly, Exhibit 1, the text with Ms. Jolie, which, as we can see, are dated to the 16th of July, 1 day after the searches in the Lutz region, which acknowledges that Mr. Gravis has at least an understanding about the NDS's presence within that region. Further, we would point the court towards paragraph 12 and the interview that Mr. Bryan gives, where he acknowledges once again that both the SPG and the NDS, as well as the police force, are present in this region and that they are following Mr. Gravis's counterterrorism campaign orders. Your Honours, we submit that the standard that is required in order to infer actual knowledge was considered in the trial chamber in the prosecution of Mr. Bemba, and it must be that this is the only reasonable conclusion. We submit that in the present case, given the entirety of the facts, it is the only reasonable conclusion to assume that upon giving the order and it being carried out, given the existence of the reporting system and the fact that Mr. Gravis knew of the troops within the region at the time, it's the only reasonable conclusion to know that, or it is the only reasonable conclusion to find that Mr. Gravis had actual knowledge of the nature of the region itself. Even if this isn't the case, Your Honours, we would submit that the existence of the reporting system enlivens constructive knowledge, and that is to say that the reporting system is a double-edged sword. Mr. Gravis either had a functioning reporting system that meant that he had actual knowledge, or in the inverse, the reporting system was defective and he would not have satisfied the duty upon him, or he would have been negligent in his duty to obtain the knowledge regardless of its availability, as was held by the trial chamber to be necessary in the case of Bemba. And as such, constructive knowledge would be found.
Counsel, as far as I remember, the judgment was generally, you know, the findings of the trial chamber have been dismissed by the reversed by the appeals chamber. So how the appeals chamber findings affect your reasoning, or it doesn't have any effect on what you said?
Respectfully,
yeah, I mean Bemba case, of course, yeah.
Yes, Mr. President. Respectfully, Mr. President, the appeals chamber decision in the matter of Bemba has no bearing on the question of knowledge. The appeals chamber in Bemba was solely focused on that third element of the doctrine of command responsibility, the scope of the duty to prevent and subsequently to repress and punish. Specifically, Your Honours, we submit that in the appeals chamber, it was ultimately held that firstly, the scope of this duty is held on a case-by-case basis, and that it needs to be taken into account using the material facts, although not solely the material facts, and that was the critical distinction. Your Honours, in the present case, we submit that Mr. Gravis has essentially done very little in regards to either the prevention or repression of these acts. On the facts, there's very little to indicate that he has taken any measures to, well, firstly to prevent them, and once they have been commissioned, to mitigate or indeed stop them and punish the perpetrators. Your Honours, I'll quickly seek to make submissions concerning Article 17 and the doctrine of admissibility. However, given that the defence ultimately seeks to rely on this, we submit that it might be best put into the rebuttal. However, at this juncture, we submit that ultimately what the defence will need to do is they have assumed the burden of proving inadmissibility in the present case. And we would point the court to the prosecution of Mr. Yekatom in the appeals chamber in 2021, where the court held that there is a general acknowledgement of a presumption of admissibility of the proceedings, and that where the defence seeks to rely on it, they bear the burden of demonstrating that the case is inadmissible, and they are expected to demonstrate the state that is genuinely seeking to exercise the jurisdiction so as to rely on complementarity. We submit that they therefore must show that there is a willingness and an ability to prosecute at first instance in order to be able to rely on the doctrine of complementarity. We submit that these are not found in the present case, and if I can assist the court no further, I would seek to conclude my submissions there.
Excuse me.
Excuse me. Yes, please.
One question to the prosecution speakers. As you know, complementarity is a core principle of the ICC legal system. And in this case, we all noticed that it was established a military court to address the issue. And as far as complementarity is concerned, you don't think that the fact to establish a domestic court is an expression of the willingness of the state to investigate accurately on these facts? And in this regard, how do you appreciate the establishment of this court? And how do you think to manage this dual system between domestic prosecutions and the ICC will to prosecute, investigate and prosecute? And moreover, do you consider that only by the fact that the case was submitted to the OTP by the Security Council, do you feel liable by the fact that the case is coming from the Security Council?
Okay, Counsel, I ask you to answer the question briefly.
Yes, Your Honours. Concerning the first question that the Honourable Judge Sémien posed, we submit that we would respond to that with two submissions. I'll make them very brief, Your Honours. The first would be that simply taking that initial investigative step might indicate a broad willingness, but it doesn't necessarily dispense with the doctrine of unwillingness, if you will. And this is to say that it might demonstrate that an action has been taken, and we cannot seek to rely on inaction to set aside a claim under Article 17. However, it doesn't necessarily demonstrate a willingness. And this was, of course, the approach taken by this court in the prosecution of Mr. Muthara, Mr. Mugwai Kenyara, and Mr. Hussein Ali. We note that in that matter, the court held that further steps then need to be taken to show that they are investigating the specific person for the specific conduct. The second point to make would be, of course, that the military investigation is ultimately being run by the military government who overthrew Mr. Gravis in September of 2021, and therefore it's not necessarily available to this in these proceedings and on these facts to ensure that this proceeding is either impartial or results in procedural fairness. Your Honours, if that satisfies the court, I'd seek to conclude my submissions.
I think the representatives of the prosecution for their submission. Thank you very much. And I would like to make sure that should defense be in the similar situation, that if we have important question to ask you, you will be also given additional time to answer the question. So please take that into account. So the court now invites defense to make submissions. Please, you have the floor.
Thank you, Mr. President. Mr. President, Your Honours, may it please the court. The principle of complementarity governs the exercise of this court's jurisdiction. This court must respect state sovereignty and only operate in exceptional circumstances. It is thus crucial that in the present case, this court respects the ongoing investigations by Hanatun authorities and render this case inadmissible before this court. Moreover, Your Honours, the court has no jurisdiction over the present case. Mr. Gravis's counter-terrorism campaign was done for the purpose of protecting the people of Hanatun from grave danger. And it is in this regard today that we make three submissions. First, that this case is inadmissible under Article 17 of the Rome Statute. Second, that this court has no jurisdiction under Article 19 of the Rome Statute. And third and finally, that Mr. Gravis is not criminally liable under Article 28 of the Rome Statute. I will address this court on the first and second issues relating to the admissibility and jurisdiction, while my co-counsel, Mr. Lim, will address this court on the final remaining issue. And Your Honours, before I move on, preliminarily, I note here that the prosecution has advanced their arguments with respect to the issues, starting with that of jurisdiction, second, Mr. Gravis's criminal responsibility, and finally, that of admissibility. However, Your Honours, I note that reading paragraph 19 of the case, alongside with the introduction of the case, it states that parties to these proceedings are to plead in the order stipulated in the agenda at paragraph 19 of the facts. And thus, Your Honours, I will be addressing this court, first starting with admissibility, second with jurisdiction, and third on Mr. Gravis's criminal responsibility. Your Honours, turning now to my first submission, this case is inadmissible because admitting the case before this court would infringe the principle of complementarity under Article 17(1)(a) of the Rome Statute. Under Article 17(1)(a) of the Rome Statute, two elements need to be proven in order for this case to be inadmissible, and both elements are present here. First, Hanatun is currently investigating the case, and second, Hanatun is willing and able to genuinely investigate this case. On the first element, the defense submits that there are sufficient steps that are currently being taken to investigate the case into Mr. Gravis. First, at paragraph 18 of the facts, if Your Honors are with me, we can see that the military court was set up to specifically address the alleged crimes committed, specifically in the region of Casteria. Moreover, Your Honors, at the same paragraph, at paragraph 18, it is stated that this military court will complete its investigations in August 2022, just a month's time. And moreover, Your Honors, on a final note, in the previous paragraph, at paragraph 17, we note that the person of interest in all these investigations, Mr. Gravis, has been held in prison for almost 2 whole years. And thus, it is the defense submission that these facts evince sufficient investigations that are ongoing into the case against Mr. Gravis. Your Honors, now moving on to the second element.
Presiding Judge, excuse me.
Counsel, may I ask you here one question? So you mentioned that Mr. Gravis is already in detention for 2 years. So what happened during these 2 years? It seems to be pretty long time, and we didn't see, at least I don't see in the case facts, any steps, you know. So what happened? It seems to be coincidence that maybe it's coincidence that the court was established just after the arrest warrant of the ICC. So what do you mean by concrete steps in the investigation of specific case of Mr. Gravis?
Thank you, Your Honor. So I note here that when we refer to concrete steps, the concrete steps that we are relying on is the setting up of the military tribunal, which is specifically targeted to address the alleged crimes in Casteria. And Your Honors, I note also your point that your concern is that perhaps more evidence should be adduced before this court. And Your Honor, your concern is actually found in this court's very recent 2021 appeals chamber decision in Yakutum. In that case, the court acknowledged that Mr. Yakutum was not personally investigating the case. Instead, he was the one being investigated. However, in the same as with Mr. Gravis here, he is not personally investigating the case into himself, but the state of Hanatun is. However, the state of Hanatun is not currently party to the present proceedings. And thus, the defense wishes this court to rely on the decision in Yakutum, which stated that a chamber must invite a state dealing with where a chamber is dealing with an admissibility challenge, where that state is alleged to be investigating a particular person. And Your Honors, to be clear, the defense submits that the facts are sufficient, but if the chamber would like to invite more evidence, the defense would like to rely on the case of Yakutum to do so.
Counsel, who's having the burden of proof in this particular issue on complementarity admissibility?
Your Honors, it is the defense that bears this burden of proof, and it is our submission that we have discharged said burden of proof to find that this case is inadmissible before this court. Your Honors, if I may move on to the second element, which goes to the willingness of Hanatun to investigate this case. It is our submission that Hanatun is willing to investigate said case. Article 17.2 of the Rome Statute provides 3 scenarios as to when a state may be adjudged to be unwilling to investigate a case. And it is the defense submission that none are present here. However, in the interest of time, the defense would focus on just Article 17.2c, which goes to whether or not the present military court is independent and impartial. And Your Honors, at this juncture, I note that at paragraph 18, it is stated that a number of high-ranking military officials had recommended the release of Mr. Gravis. However, the defense submits that this does not impinge on the independence and impartiality of the military court. Instead, what matters is whether the judicial authorities dealing with the case had made those views, as held in this court's pre-trial chamber decision in Gaddafi. And here, clarification 3 states that the high-ranking military officials have no connection to the military court, and thus Hanatun is not unwilling to investigate the present case. Your Honours, having submitted on admissibility, I will now move on to my second submission, which goes to the jurisdiction of this court. The defense submits that this court does not have jurisdiction because the requirement of subject matter jurisdiction is not satisfied in the present case. The elements of crime of the Rome Statute provide that there are 4 and 5 elements respectively for the crimes of genocide under Articles 6A and 6C of the Rome Statute. These elements are conjunctive, which mean that if the defense proves to this court that any of the elements are not present, this court does not have subject matter jurisdiction. And thus, the defense submits that there are no reasonable grounds to believe that the case against Mr. Grebus constitutes genocide because the forces did not have the specific intent to commit the crime of genocide. And Your Honours, it is here we note that with respect, the prosecution appears to have erred in the law in submitting that Mr. Grebus is required to have the specific intent pursuant to elements 3 of the elements of crime. On the contrary, it has been consistently held by ad hoc tribunals that the specific intent needs to be that of the forces committing the crimes. And this has been held in the 1998 ICTR trial chamber decision in Akayesu, the 2010 ICTY trial chamber decision in Popovic, and this court's very own appeals chamber decision in the 2010 decision of Al-Gaddafi. And Al-Bashir. And thus, it is the prosecution that bears the burden of proving that it is the forces on the ground who have allegedly committed the genocidal acts who possess the requisite specific intention. However, such facts are not present here. Your Honours, all the information, Mr. President, I note you have a concern.
Sorry, again, may you please, could you please address the facts of the agreed facts that the forces, the troops actually, so especially SPG men, they chanting the message of Mr. Grebus that Castilians had cancer. There are also there is also evidence that Mr. X was actually released just on the basis of being non-Castilian. So there are certain facts that point to the subordinates, to the forces in the field. So can you please address these facts?
Most certainly, Your Honour. On the first fact, we note that the facts are stated at paragraph 12 to 14, which include that of the SPG forces chanting the phrase Castilians of cancer, and as well as other facts that have been relied on by the prosecution, all stem from a single information report. And we note here that it is an uncorroborated source of information, namely the IHRD report. Your Honours, the defense submits that little probative value should be given to said report and thus the facts therein. The defense here is not saying that this report is inadmissible before this court. We note that there is nothing in the Rome Statute or the Rules and Procedure of Evidence which forbid this court from admitting NGO reports as evidence of given facts. However, what we are saying is also stated in this court's 2011 pre-trial chamber decision in Barushimana, where the court held that it is not sufficient for the prosecution to rely solely on a report by an NGO to support a charge that a specific incident had occurred. Thus, in absence of any corroborating evidence that these forces had, for example, chanted Castilians are cancer, or for example, whether the forces had killed the 200 Castilian men, it has not been proven on the facts that these facts had occurred, and thus the specific intent to commit the crime of genocide is not present. Moreover, Your Honours, to address your second concern as to the fact that Mr. X was released when the forces had found out that he was of Hanu ethnicity, the defense would first submit that even if we assume that Mr. X's account is true, in establishing the crime of genocide, it is well known that an ethnicity is not defined in the negative. What this means, and this was held in this court's 2009 pre-trial chamber decision in al-Bashir. And what this means is that it's insufficient to say that because the forces had released Mr. X, they therefore targeted non-Hanus and therefore targeted Castilians. In fact, it must be shown that the forces had targeted members of the Castilian ethnicity because they were members of the Castilian ethnicity. And Your Honours, moreover, nonetheless, the defense submits that similarly, minimal probative value should be given to Mr. X's account. This is because Mr. X's statements are anonymous hearsay, and it is uncorroborated by any other evidence. This chamber has held that it cannot rely solely on anonymous hearsay evidence and may only do so to the extent that it corroborates other evidence. And this was stated in the 2008 pre-trial chamber decision in Kathanga. And thus, Your Honours, in absence of corroborating information for both the IHRD report and Mr. X's account, the defense submits that it has not been proven that these incidents had in fact occurred and the specific intent to commit the crime of genocide is not present. Your Honours, on a final note, we note that the counter-terrorism campaign by Mr. Gravis was in fact a legitimate effort to clamp down on terrorist threats in Castilla. And we note that at paragraph 9 of the facts, it is stated that the CNF had conducted violent demonstrations that resulted in dozens of police being killed and many more seriously injured. And most egregiously, a military cargo for the National Defense Division of Hanatun was ambushed, causing 35 soldiers to be burnt alive. And so here, while it is unfortunate that lives were lost in the counter-terrorism campaign, this is justified by the need to uphold national security against potentially even more lives from being lost to terrorist hands. And thus, the forces did not intend to target the Castilian ethnic group. And hence, the counter-terrorism campaign, despite what is argued by the prosecution, was not a genocidal plan, but a genuine effort to protect the people of Hanatun. And Your Honours, for the foregoing reasons, we urge this court to find that this case is inadmissible and that this court has no jurisdiction. I'll now be passing my time to my co-counsel who will bring this court through the remaining issue.
Thank you, counsel.
Mr. President, Your Honours, may it please the court. As earlier introduced, my name is Ezra Lim, and I act on behalf of the accused, Mr. Gravis. I'll address Your Honours on the final issue concerning Mr. Gravis's criminal responsibility under Article 28 of the Rome Statute. Your Honours, Article 28 enshrines the doctrine of command responsibility and seeks to ensure that a commander cannot escape liability simply because the crimes were committed by subordinates. Today, the defense submits that Mr. Gravis is not liable under Article 28 because two elements required to establish his liability are not present. To this end, we make two submissions. First, that Mr. Gravis did not have effective control over his forces, and second, that Mr. Gravis did not possess the requisite mental element of knowledge required to establish his liability. Turning now to my first submission, that Mr. Gravis did not have effective control. Effective control is defined as the material ability to prevent or repress the commission of crimes. And this was held in the 2009 confirmation of charges decision in Bemba. Now, the defense notes that the prosecution earlier made brief submissions on the point of effective control, relying on the fact that there were boots on the ground after Mr. Gravis had given the order, and the fact that there was no suggestion of any form of dissent that the powers of Mr. Gravis had been usurped. It is our submission today that the prosecution has yet to satisfy this court on this element, and in this respect, we make two related points. First, the troops on the ground had acted outside the scope of Mr. Gravis's orders and undertook actions that they had not been permitted to. This is contrary to the prosecution's submissions that there had been no dissent or usurping of his powers. If your honors will turn with me to paragraph 11A of the facts, we see that Mr. Gravis's orders were that the forces on the ground were only to target threats to national security and the public order of Hanatun. However, the forces had not complied with such orders on a few instances. At paragraph 13, when the SPG soldiers were seen kicking pregnant women in the stomach, and at paragraph 14, when 86 male companions of the female Castilians were shot, and more pertinently, when they forced Castilian women to provide sexual services under the threat of death. Now, these actions were clearly not taken in the interest of the public order of Hanatun or to address national security, and as such, they clearly fell outside the scope of Mr. Gravis's orders. And a disregard or non-compliance with orders is a factor that may indicate a lack of control, as held by the 2016 trial chamber decision of Bemba. Now, your honors, if your honors will turn with me to exhibit 1 of the facts. The text message exchange between Ms. Jolie and Mr. Gravis show Ms. Jolie not presenting the full facts of the situation on the ground to Mr. Gravis. She describes the situation as under control, and when further pressed about civilians, Ms. Jolie tells Mr. Gravis that civilians are released when mistakenly arrested. Now, nothing in her report had alerted Mr. Gravis to the fact that just the day prior, 198 civilians were shot, as seen from paragraph 12 of the facts. It is thus clear that Ms. Jolie had concealed the full extent of the events on the ground from Mr. Gravis, and this would prevent Mr. Gravis from ensuring that his orders were complied with, and this is a factor that indicates effective control, as held by this court in its 2009 confirmation of charges decision.
Counsel, may I stop you here? Are you talking about the knowledge actually, or the control? So it's a little bit, I think, two different questions in this case. Can you address specifically the prosecution submission on this point? Because there was two arguments, one about the effective control, but the other one was about what they call kind of constructive knowledge stemming from the position and the position of Mr. Gravis in the hierarchy of power. So please, could you address this specific point?
Certainly, Your Honor. This point about knowledge we submit has some relevance to effective control insofar as it allows the commander to know what his troops on the ground were doing. And Your Honor, I will turn now to my second submission on knowledge. The defense submits that Mr. Gravis did not possess the requisite mental element of knowledge required to establish his liability. Now, the defense notes that in this case, either actual knowledge or constructive knowledge is sufficient to establish his liability under Article 28A. However, as the prosecution relies on that of actual knowledge, we shall meet their case where it is at. Now, the defense accepts the prosecution's submission that actual knowledge can be shown through direct or circumstantial evidence, but the defense wishes to reiterate that actual knowledge cannot be presumed. Now, earlier, the prosecution relies on two main factors to establish that Mr. Gravers had knowledge. First, the text message by Ms. Jolie, and the fact that at paragraph 11E, the heads of the forces were to report to Mr. Gravers the situation on the ground. The prosecution argues that if the heads of the forces had accurately reported to Mr. Gravers, this would be actual knowledge on his part. And if they did not report properly, this would constitute constructive knowledge because of Mr. Gravers' active duty. However, the defense submits that the prosecution's argument cannot stand in the present case, because what we have in the present case, in Exhibit 1, is a direct question by Mr. Gravers as to what happened on the ground. And we submit that this fulfills his active duty. The fact that Ms. Jolie had not presented the full facts to Mr. Gravers does not mean that should not be sufficient for Mr. Gravers to be held liable. Now, while the defense also—
Excuse me, counsel.
Yes, Your Honor.
So actually, so according to the exhibit, so you can find the concealing by the Miss Jolie. So, but particularly about the killing, I think, about blockade of the area. What do you think about? At least, according to the report or the SNS, so Mr. Davis could know the situation, current situation in the custodian, I think. What do you think about that point?
Certainly, Your Honor. Mr. President, I know that my time is running out. If I might just have 1 minute to address Your Honor's question.
Counsel, just conclude your statement. Yes, you may use some time.
Much obliged, Your Honor.
Be brief, please.
Certainly, Your Honor. To answer Judge Doi's question with regard to the blockade, at paragraph 16, Mr. Gravers mentions that the situation in the economic situation in the whole of Hanatun had deteriorated, and that his government was trying its best to control the situation. Thus, while Mr. Gravers knew that there were deaths due to the famine, he did not have knowledge of the alleged blockade by his forces, and he did not know that this was allegedly a deliberate attempt by the forces to inflict conditions of life on the Castilians. Rather, to the best of his knowledge, his government was already dealing with the economic crisis, so it could not address the additional problem of the humanitarian catastrophe going on. Your Honor, to conclude my submissions, we submit that Mr. Gravers cannot be held liable under Article 28 because he did not have effective control, neither did he have knowledge of the crimes, of the alleged crimes on the ground. Unless I may be of further assistance to this court, this concludes my submissions. May it please.
Thank you, counsel. The court thanks defense for their submissions, and now the parties already indicated their wish to rebut the opponent. So I give the floor to the prosecutor, to the prosecution, please.
Thank you, Mr. President. Your Honours, we have several points to make today in rebuttal to our learned friends. The first one, however, the first point to be made doesn't actually concern an article per se, but rather a procedural criticism that our learned friends made against us. Specifically, they criticised us for not following the agenda in the present matter. However, we would point the court towards Rule 58, subsection 4 of the ICC Rules of Procedure and Evidence, where it states that the court shall rule on any challenge or question of jurisdiction first, and then on any challenge or question of admissibility. It was on this basis that we structured our agenda of arguments the way we did. Your Honours, concerning Article 17 first, we submit that our learned friends have suggested that there is not sufficient evidence in this proceeding on the basis that Hanatun has not been called to testify as a state. And that is, of course, reflective of the Yektom decision by the Appeals Chamber. However, we would point out that additionally in the Yektom decision at paragraphs 43 and 44, it was stated that ultimately the burden lies with the party who is seeking to rely upon declaring the matter inadmissible. And then in the present case, that is the defence themselves. We suggest that it is illogical for the defence to raise the defence of inadmissibility and then complain about insufficiency of evidence. It appears to be incongruous. The second point to be made concerning Article 17, Your Honours, is that at this juncture, we are still yet to hear what investigative steps have been taken in accordance with the military investigation beyond its mere inception. Your Honours, turning to Article 19, our learned friends made submissions concerning the subject matter jurisdiction. Specifically, we note that the defence suggested that we erred in our interpretation of the law concerning the specific genocidal intent, and the defence instead submitted that the Honiton forces were required to hold the requisite genocidal intent. Here we would seek to refer to the only ICC decision on the matter of genocide, in which the arrest warrant granted against Mr. Omar al-Bashir at paragraphs 147 to 151, the pretrial chamber found that there were reasonable grounds to establish Mr. al-Bashir was affecting his genocidal intent through the use of his security forces as ultimately their leader, and that as such the genocidal intent transferred to them. Your Honours, the final points to be made here concern Article 28. We submit that our learned friends determined that there were two elements on which our submissions fell down, the first being the effective control element. We concur with the establishment of the test, the material ability to prevent or repress, that is ultimately conclusive of what effective control will be. However, we submit that the notion that the acts were outside the scope of Mr. Gravis's orders is one that is not necessarily consistent with the approach taken by in the jurisprudence of the doctrine of command responsibility. We would point to the fact that the doctrine of command responsibility need not be specific in that regard, and we would point to, amongst other factors, the first additional protocol to the Geneva Convention, which ultimately is the inception of this doctrine, specifically Articles 86 and 87, which state that the leader is not absolved on the basis that they did not have absolute control over their subordinates. Rather, it is their duty to ensure. And that is the basis that we submit that effective control has been birthed on. Further, we would point to the fact that regardless of whether they took it too far, they were still in the region carrying out his orders, and that there is no notion that they were seeking to undermine them. The final point to be made, Your Honours, concerns that of knowledge. Your Honours, we submit that our learned friends have made submissions that Ms. Jolie was not forthcoming, and that furthermore, Mr. Gravis has executed his duty to obtain the relevant information by sending or by having one text conversation. We submit that, of course, this is to be determined on a case-by-case basis in accordance with the material ability of the leader. In the present case, Mr. Gravis, as I've stated several times, is both the President and the Commander-in-Chief. We submit that given the resources at his disposal, including the reporting system, one solitary text, even if the respondeur is not overly forthcoming, is not sufficient to execute this duty. If the court has if I can be of no further assistance, I would seek to conclude my submissions there.
Thank you very much.
Please.
So defense, you have the floor.
Thank you, Mr. President. Mr. President, Your Honours, may it please the court. The defense submits 4 points in its rebuttal. First, we will deal with the preliminary point made by the prosecution here, that they have structured their submissions in a way to adhere to Rule 58 of the Rules and Procedure of Evidence. The defense does not dispute the law that under the Rules and Procedure of Evidence, Rule 58 in particular, this court may rule on jurisdiction first, followed by admissibility. Your Honours, I note the word is rule, but it is not, whether the court may rule on jurisdiction first has no bearing on whether the court may hear submissions on admissibility before that of jurisdiction. And thus, we urge this court to pay heed to the stipulated agenda that has been unequivocally stated at paragraph 19 of the facts to address the issues in the provided order. Your Honours, moving on to the first point of rebuttal, which is that of admissibility. We would like to clarify here that the prosecution has misinterpreted what we have submitted. We are not saying that the facts are insufficient on the case to show that investigations are ongoing. On the contrary, the defense submits that that given the specificity of the military court's investigations into Casteria specifically, as well as the fact that Mr. Gravis is being held in prison, this is sufficient to show that this case is inadmissible before this court. Our reliance on the 2021 Appeals Chamber decision of Yakutum is simply to assist this court further in adducing more evidence as to what are the precise investigations that Hanatun is carrying out. Mr. Gravis has been held in prison for over 2 years, and it is Hanatun that is investigating into him, and thus they are best placed to answer this question and provide assistance to this court. Second, Your Honours, on jurisdiction, we note that the prosecution has, with respect, still relied on the case of al-Bashir in its trial chamber decision. However, Your Honours, we would like to point this court to the al-Bashir Appeals Chamber decision, which is the decision on appeal from that pre-trial chamber, which stated at paragraph 103 that it is the government of Sudan and their troops' intention that was important to adjudge whether the crime of genocide had been committed. And after that, other modes of liability may then be accorded to al-Bashir himself. But it is primary that in that case, they focused only on the specific intent of the troops of the government of Sudan. Third, Your Honours, on effective control, the defense reliance on the disobedience is that even if Mr. Gravis did give an order to stop the crimes, it would not have been followed. However, this does not stand, again, because of the pattern of disobedience that we have seen from the present case facts. Mr. Gravis only ordered for a counter-terrorism campaign to stop the CNF terrorists from jeopardizing the safety and security of the people of Hanatun. Yet, SPG officers were allegedly seen kicking pregnant women and chanting Castilians are cancer, and these are not at all stipulated in Mr. Gravis's orders. Your Honours, on my fourth and final rebuttal on knowledge, the prosecution suggests that at all times, Mr. Gravis could have asked for more with his given resources. However, the defense submits that the report was sufficient, and we've emphasized with Mr. Gravis further how Mr. Gravis actually asked about the safety of his civilians, and this shows of him being a responsible commander in this regard. Mr. Gravis had thus fulfilled his active duty and should not be faulted because his subordinates did not follow his commands and concealed the facts of the case to him. And thus, Your Honours, in light of the foregoing reasons, we urge this court to find that this case is inadmissible, that this court has no jurisdiction, and that Mr. Gravis is not criminally liable under Article 28. And unless I may be of any further assistance.
Thank you very much.
Thank you, Mr. President.
So the hearing is coming to a close. The court is now adjourned. We will be coming back with a verdict in a certain time. Thank you very much again, and please, bench clerk, announce the adjournment. Okay, welcome back. I see the teams are ready. So ask Bench Clark whether it's fine with the with the streaming. Everything is fine. Okay, so can we actually start? Yes, thank you. We can be a little bit less formal now at this stage. So first of all, congratulations to both teams. It was really a great round. So we judges have been absolutely unanimous, not only in our verdict, but in appreciation that both teams performed greatly. We have been impressed. Of course, it's expected from the quarterfinal that the teams who advance to this stage are well prepared and capable to plead in a high level. But actually, it's a pleasant surprise that the team have been so well equipped with the knowledge, also, you know, very professional skills. So that's we have seen probably people who are already could do very good job in the international criminal justice. So that's truly a great round. So we have been honored to assist you today. So I think it was our job to assist you, not to somehow impose rules on you. So that's the first thing I would like to say. So there was a difficult choice that we had to make, because actually both teams deserve to proceed to advance to the further round, but unfortunately we have to decide on that. So before I announce the verdict, I understand that it's most important part for you. I would like just to make several points on which judges have been united, and which we would like to make certain points during this feedback. If my colleagues would like to, you know, wish to make additional points, they interrupt me without, I think, doubt. So first, we would like to say that the both teams have been very good in organization of their presentations. Timing was perfect, was just, you know, absolutely great. Also the pace, which is crucial problem during many of the rounds when the judges have to follow the arguments of the parties, and here you have been perfect. So keep it like that. It was perfect for both virtual and in-person hearings. Like that was very good, very well done. Also, both teams refer to jurisprudence, and this is also a very strong point of both teams. So you have referred to lots of cases, but you did not overdid that. So you didn't flatter us with this, you know, multiple cases. You have been precise. You answered the question about this, you know, references. So it was very good, very well done. You also use certain arguments which have been developed in not only in the case law, but also in the theory of international criminal law, which is also appreciated, and a good balance between the, you know, kind of scholarly points and the jurisprudence. Procedural point which raises tensions, I think, between the teams. 2 points. It's about the order. It's about the following agenda of the hearing. So the prosecution made a kind of brave move to change the order and to a little bit not to address in depth the complementarity, the admissibility issue. We find that it's not a violation of the rules of the agenda hearing. It doesn't say anything about the order, but it's a questionable step at the same time. So we have been somehow deprived of the discussion on the important issues. So I think complementarity in this case was an important part of the problem, and in particular in light of the recent jurisprudence of the International Criminal Court. So it's, I think, could be kind of thought before. So that we expect some more, extensive discussion on this issue. So, but generally, it was a critical point to prosecution. But at the same time, I would like to emphasize that I generally appreciate your kind of flexibility. So you have been very, on the one hand creative, but at the same time you have been flexible in answering question and in your argumentation. So that's a strong point. But you have to be careful in when a certain way certain expectations do exist, and it's no way a good idea to say something that you said, well, we could back to this in rebuttal. Rebuttal is not for that. Rebuttal is not extension of your presentation. It's a response to specific points raised by opponents that you didn't hear at that point. So that's a little bit not very careful thing. Also, generally, what was probably missing, it's my personal point, what we call of course it's not specifically a big part of the criminal law, international criminal courts, but something which we call policy arguments. So some arguments that are based not only on the strong legal points, but on the kind of functional approach. So what we want to achieve and what kind of policy issues underlie your arguments. So that is always kind of part of the good submission, and especially in moot courts, it's very helpful sometimes, because policy arguments, when they use, of course, smartly, when they don't replace the legal arguments, they help to convince the judges, because the judges, they hear strong legal argumentation, but they also need something to be persuaded, to be convinced. So that's one of the problems, by the way. I think more of the prosecutor team, they have to be, you have to think what kind of effect your arguments can have on the judges, especially when you talk about certain sensitive issues like the loss of life, the violence. That's not that easy. You can be absolutely valid. It can be absolutely valid points in terms of the law, but at the same time, politically can be, policy-wise, it can be questionable. So that's there are also many other points that you could make, because it was just a great round, and I'm sure that both teams really did a good job. So that turns me to our decision. Again, it was relatively easy to make because we have all the same opinion, the same point, but it was difficult in terms of that it's kind of close round indeed, So first I turn to the speakers. Okay, speakers. All 4 speakers today have been great, and they all deserve to be mentioned. So that's something I would like to proceed the announcement, because it was a difficult choice as well. So we decided that the second best speakers of today's round is actually the first speaker of the defense team. So it's Miss Natalia Maido-Ngok. Apologize if you are not correctly spell your name. Congratulations, that was really good performance. And that the best speaker today is the second speaker of the prosecution team, Mr. Jeremy Brown. So also congratulations. As I said before many times already, there was a very close round, so we didn't find big, margin between the teams. But based on our criteria, we decided that the winning team today is prosecution. So congratulations to the winning team, but also congratulations to defense. We really appreciate your performance and wish you good luck. International criminal law in particular needs you, and welcome your further success and wish you good luck. Thank you very much. And finally, I would like to thank my fellow judges. It was a pleasure to work with you as well. Thank you.
Thank you very much, all, and thank you particularly to Team 34.
Thank you so much, Mr. President, Your Honours, for being with us today. And thank you to the prosecution for being here with us as well. I wish you all the very best for the rounds ahead.
Thank you.
The ICC is now adjourned.